introduction because we already know him through his various works in the field of arbitration as well as investment treaties. But still, to know him better, I would give a brief introduction of his. So currently, Sir is working as a senior assistant professor at Faculty of Law, South Asian University. He has completed his LLM from University of London, jointly at School of Oriental and African Studies and University College London, and he has completed his PhD from King's College London, United Kingdom. He has various academic honors and scholarships to his honor. To name a few of them, he was a visiting scholar at Brookings, India in the year 2017 and 18. He has also been the part of the Transnational Summer Law Institute Fellow at Transnational Law Institute, Dixon Bloom School of Law, King's College London in the year 2016. He has been the visiting fellow at Lawton Pact Research Center for International Law at Faculty of Law, University of Cambridge from May to July in 2015. And there are many more to go such. He has various publications also to his honor. And one of them is what he shall be discussing with us today, which is his book available on Amazon. I've already shared the link with all of the students on Moodle. And it is on bilateral treaties and India, and it focuses on investment treaty arbitration. And the whole book's name is India and Bilateral Investment Treaties, Refusal, Acceptance, and Backlash. It has been published by Oxford University Press. He has various peer-reviewed journal articles also to his name. Over to you, sir.
Thank you very much. I'm extremely grateful to Nirma University for this kind invitation. And I'm extremely humbled by seeing the number of students who have joined for this lecture. I hope after 1 hour, you will not be disappointed and you will not think that you have wasted your time. So I hope I will be able to live up to your expectations. As it was just mentioned, what I'm going to speak today to all of you is about investment arbitration, or more specifically, bilateral investment treaties. And I'm going to focus on what has been India's journey as regards bilateral investment treaties. And whatever I'm going to talk about is part of this book, which I have written, India and Bilateral Investment Treaties, Refusal, Acceptance, Backlash, published by Oxford University Press in 2019. The book is available on Amazon, just in case any one of you is interested. Before I come to the topic, I would like to tell you very briefly about, about the academic journey or the journey as a researcher that I have gone through while doing research on this topic. In 2006, and hopefully this would be interesting for young law students like you, because today the world has changed quite a bit. But it wasn't so about 14, 15 years back. When it came to investment treaty arbitration or bilateral investment treaties. In 2006, when I went for my LLM to London, and I was first exposed to this particular subject, it really interested me and intrigued me. And what really caught my attention was that there is so much that is happening on this subject all over the world, but this is not really an area or a topic on which anybody talks about this in India. And then I discovered way back in 2006 that India had already signed more than 60 to 70 bilateral investment treaties by 2006, which sort of further aroused my interest in this subject and made me ask that if India has indeed signed so many investment treaties, why is it that no one talks about these treaties? Why is it that there is no or very little research that has been done on these treaties in context of India? And this made me decide that maybe it's time to do research on this area, because there is a lot that has happened, but nobody has talked about it. Nobody has documented it. And therefore I started doing my LLM dissertation on this topic, which I submitted in 2007, followed by later my PhD thesis at King's College London on the same topic. So I have been working on this topic for last close to 15 years now. And I have lived through the trials and tribulations, if one can say, of India's journey with respect to bilateral investment treaties. So in my book, I have tried to divide India's journey on bilateral investment treaties or investment treaty arbitration. It is completely up to you how do you call it. Basically into three parts. And I call these three parts as which is the subtitle of the book: refusal, acceptance, and backlash. So in my lecture today, what I'm going to do is to take you through all these three different periods of time in in independent India's history, that is from 1947, and explain to you not just what has been India's approach to investment treaties, but also what has been India's approach to foreign investment in general. Because as you would appreciate, how a country deals with investment treaties is a direct function of how the country deals or how the country perceives foreign investment per se. And as I have tried to document in the book, there are very interesting parallels between India's approach to foreign investment and India's approach to investment treaties in all these three phases that I'm going to talk about: the phase of refusal, the phase of acceptance, and the phase of backlash. So let me first start with the phase of refusal. And this phase runs from 1947 till 1990. Now, you might wonder that this is a very long time period, from 1947 till 1990, of more than 4 decades. So can time that was for as long as 4 decades could be clubbed as one phase, the phase of refusal? The answer is yes and no. Yes, and if you're wondering that why do I call this as phase of refusal, the simple explanation is that this was the phase of refusal because India did not sign any bilateral investment treaty at this in these 4 decades. Uh, in fact, India refused signing bilateral investment treaties in these 4 decades. But for a further or a more nuanced understanding, it is important that we divide this phase also into two phases. And these two phases are: the first phase was when Jawaharlal Nehru was the Prime Minister of India from 1947 till 1964. And the second phase was from 1965 till 1990, when you had Lal Bahadur Shastri, Indira Gandhi, a brief period where we had the Janata Party government, and then followed by Rajiv Gandhi, Indira Gandhi, and then again by Rajiv Gandhi till 1990. So even this 4 decade period, I divide into two parts: 1947 till 1964, and then from 1965 till 1990. Now, what is interesting, I will first talk about what was India's approach to foreign investment per se, because this understanding is important for us to understand how India approached the topic of investment treaties. Contrary to several myths, or several a lot of academic literature that floats around on WhatsApp University, it is important for us to keep in mind that India's initial approach to foreign investment was not of rejecting foreign investment. From 1947 till 1964, India had a very cautious approach to foreign investment, which is that while India, on the one hand, was conscious that foreign capital, or India saw foreign capital with a certain degree of skepticism because of its colonial rule. This never meant that India did not welcome foreign investment. In fact, as I have argued in my book, from 1947 till 1964, India was very clear that we would attract, or we would allow foreign investment to come into India as long as it adds to India's productive capacity, as long as it adds to India's economic growth and economic development. So while foreign investment was restricted, it is not that all the sectors were open to foreign investment. However, there were quite a few sectors where foreign investment was allowed. And foreign investment did come into India from 1947 till 1965. Another very interesting facet of India's approach to foreign investment at this point of time, in comparison to other countries that had gained independence from their colonial masters, was that in India there were no cases of expropriation, or there were very few cases of expropriation. Unlike if you compare this with countries like China, where foreign investment was expropriated and no compensation was paid to the foreign investor. In India, even if there were instances of nationalization, in all these cases, due compensation was paid to the foreign investors. So there was not even one case during this period where India nationalized foreign investment and did not pay compensation. And secondly, India did not go on a nationalization spree as it happened in several other countries. And this was for very good reasons. And the reasons were that while India imposed its faith in public sector, India wanted to develop its economy based on the public sector model, and which was not surprising because this is what most of the, or in fact, all of the Asian and African countries who gained independence from their colonial masters believed in. But at the same time, this never meant that India rejected the private enterprise or private capital. Private capital was also welcomed as long as it added or it contributed to the overall growth of the economy. So therefore, there were two basic key characteristics to summarize this period from 1947 till 1965. Foreign investment was cautiously embraced, and secondly, there were no mass nationalizations of foreign investment. And even if nationalizations took place, foreign investors were given due compensation. These nationalizations were followed on the basis of due process. Now, one of the reasons for this was that, if you would remember, right to property was recognized as a fundamental right when the Constitution was enacted in 1950. It is only later that the right to property was robbed of its status of fundamental right and became merely a constitutional right. But right to property was a fundamental right. And this of course played an important role in ensuring that foreign investment, if nationalized or if expropriated, it cannot be without due process and without giving due compensation to the investors. Now, this cautious, welcoming approach to foreign investment also reflected into India's approach towards international law on foreign investment. A very important fact that many of you might not know and many scholars have not talked about, which I discuss in my book, is that India did sign two investment guarantee agreements during this period. One such investment guarantee agreement was signed with the US, and the other was signed with West Germany. Now, these investment guarantee agreements were not like bilateral investment treaties, but these investment guarantee agreements came closer to India accepting the bilateral investment treaties at that time itself. So these investment guarantee agreements basically acted as a kind of assurance being given to foreign investors from US and from West Germany who wanted to invest in India, that your investment will be safe, your investment will be secure. And if you want to repatriate profits, or if you want to dispose your investment and transfer the proceeds, you will be allowed to do so. So it was it's quite interesting to note that although India did not embrace investment treaties or refused to sign investment treaties during this period, India did adopt a limited investment guarantee agreement provisions, which contained provisions for the protection of foreign investment. Another very interesting thing, which I presume many of you would know, it was during this period that India also decided to take part in the negotiations for the ICSID Convention, the International Center for Settlement of Investment Disputes, which finally came into existence in 1965. You might have come across work of many scholars who would, in a very sweeping fashion, state that India did not sign the exit convention because India was largely a socialist country. It followed a socialist model of development, etc. While it is true that India was inspired by socialism, and India was not the only country, a large number of countries at that time were inspired by socialism. Again, no surprises, because countries that had suffered at the hands of colonialism for 200 years would not get attracted to capitalism at that stage. So India was inspired towards socialism. Indian economy was what can be loosely called as a socialistic economy. However, this was not the reason for India deciding not to take part in exit negotiations or not to sign exit. As I have documented in my book, India took a very active part in exit negotiations, made very useful suggestions during the drafting of the exit convention. However, finally, India decided not to sign or not to accede to the convention, largely because it had concerns about jurisdictional issues, etc. But India did take a very active part in exit negotiations, which also demonstrates that India did not had that kind of opposition as many people portray towards investor state dispute settlement. So this was the first phase within the refusal phase from 1947 till 1965. To quickly recap, India had a cautious approach towards foreign investment. It did not indulge into nationalization, and it entered into a limited form of investment protection or investment guarantee agreements with countries such as US and West Germany. Now I will talk about the second part of the refusal phase, which started from 1965, that is after the death of Nehru. And this phase, in fact, especially after Nehru's daughter, Indira Gandhi, became the prime minister. This phase was different from the initial phase of refusal. And during this phase, from late 1960s and especially in 1970s, India turned much more leftward, and this turn was not because of ideological reasons, but this turn was largely for political reasons. Indira Gandhi was fighting a very tough political battle, and for her political survival, uh, she had to turn leftward and become more populist in her approach. And this also translated into a lot of changes in the economic policy. So, for example, during Nehru's time, you didn't have bank nationalization. Bank nationalization took place when Indira Gandhi was the prime minister. Likewise, during Nehru's time, there was only nationalization of life insurance. But during Indira Gandhi's time, you had the nationalization of general insurance, and not just general insurance. You also had the nationalization of coal, of aluminium, of economic activities. And there's a very good book written by a scholar called Shubhankar Dan, who writes about how ordinances were used during this time to enact almost all of these nationalizations. And there's again a very important lesson that how powerful prime ministers and powerful governments often use ordinances to bring in contentious legislations because they do not want to confront a parliamentary debate, or because they cannot convince parliament, etc. Of course, ultimately it has to be passed by the parliament, but you would expect that such contentious nationalization decisions are not made or should not be made by ordinances. But this was the route that was followed during that time. Foreign investment was really made a very dirty word, or became a very dirty word. So while Nehru had a very pragmatic approach towards foreign investment, Indira Gandhi had a more ideological approach towards foreign investment. Anything that was bad was blamed on the foreign hand during the 70s. And one of the important things that we saw during this time was enactment of several other legislations, economic legislation, such as the Foreign Exchange Regulation Act, or FERA, uh, uh, which led to a large number of foreign investments being disinvested or divested in order to reduce their equity. And those companies which refused to do so were ultimately forced, or were left with no reason but to exit India. Companies such as Coca-Cola, companies such as IBM, etc. Likewise, you had another very draconian economic legislation that was enacted, known as the Monopolies, Restrictive and Trade Practices Act, the MRTP, which also had disastrous consequences for private enterprise and investment. It defined monopolies in a very unusual fashion, which created incentives for private businesses not to expand, not to become big in size, because if they became bigger in size, then they would be automatically construed as monopolies, which would have a disastrous impact on the economy. So as a result, a lot of inefficiency crept into the system. Indian industry was not competitive. It was unable to compete with industries of East Asia and of other countries. And as a result, the Indian economic growth, which was more than 5% after independence from 1947, 1950 till 1964, the Indian economy grew at roughly 5%. During Indira Gandhi's era, this economic growth fell down to close to 3%, and this was an outcome of a large number of these wrong policies or wrong laws which were enacted and implemented at that point of time. No prizes for guessing that as a result, India did not sign any investment treaty during this period. On the contrary, at the global level, India took a very active part in developing what is known as, or what can be described as, the new international economic order. As part of this new international economic order at the UN, there was a Charter of Economic Rights and Duties which was adopted. And this Charter of Economic Rights and Duties basically said that foreign investment is to be regulated by national laws or by domestic laws. And if foreign investment is expropriated, then compensation should be paid to the foreign investor. However, the questions of compensation should be decided on the basis of domestic or national laws of the country concerned. So the entire focus of India and of a large number of developing countries globally at that point of time, especially in 70s, was to have domestic law as the fulcrum, domestic law as the basis to regulate foreign investment, and not to have international law as the basis to regulate foreign investment. And what in my book, what I have tried to do is that I have tried to locate what India was negotiating or demanding or arguing globally with what India was doing domestically and what was India's political economy at that point of time. And this is another important sort of sub narrative that I want to have here is that it is often said that Nehruvian India was socialist, but that is actually not true. The Nehruvian India was socialist, but it wasn't socialist in the bad sense in which India became during the Indira Gandhi eras, during 1960s and 1970s. Finally, we all know that we had the emergency, then Indira Gandhi lost the elections. We had a coalition government which did not last, and Indira Gandhi came back to power in 1980. But this time, when Indira Gandhi came back to power in 1980, this was a little different. The leader had changed or had evolved or perhaps learned from the past mistakes. And in 1980, what India started to do was to lift some of the controls that it had imposed on economy. So there was a partial deregulation or a partial liberalization of the economy that started in 1980s with Indira Gandhi as the prime minister, and which was followed by Rajiv Gandhi as the prime minister, who sort of and India started to look at foreign investment in a slightly different fashion. However, in the decade of 1980s, while Indian economy grew at a healthy 5.7% growth rate, a lot of this growth rate was fueled by debt. It was fueled by a lot of borrowing by the government, which finally led to a very severe fiscal crisis in 1989, especially in 1990, when India had money to cover imports or to pay for imports of just a few weeks. And it was in 1991 that India changed its gear completely as regards its economic policy is concerned. Although the seeds of this were sown in early 1980s, but it was in 1991 that India changed its gear completely and adopted a very different economic paradigm, a very different economic policy than what it had been following earlier. And under the leadership of P.V. Narasimha Rao and Dr. Manmohan Singh, who was the finance minister, India unleashed a series of structural reforms in its economy. So the rupee was partially devalued. Foreign direct investment was welcomed. A lot of sectors were liberalized for foreign direct investment. Import tariffs or custom duties that were generally very high were brought down, so on and so forth. So India, in the 1991 budget that Dr. Manmohan Singh presented, India very clearly signaled that it was adopting a different economic paradigm from what it had followed in the first 4 decades of independence. And a very important element of this changed economic paradigm was that India was now open to accept more foreign investment. And therefore, attracting foreign direct investment became a very important pivot of the new economic paradigm that India adopted in 1991. And this change towards India's approach towards foreign investment finally led India to what I call as the phase of acceptance, the second phase that India entered in 1991. So, because of this liberal and open approach towards foreign investment, India decided to sign investment treaties, and the first such investment treaty was signed in 1994 with the UK. Now, there's a very interesting story behind this, as I have written in my book, that when Dr. Manmohan Singh went to the UK after presenting his 1991 budget, and he met several investors in the UK, and he was encouraging them, persuading them to come and invest in India. He was asked this question by the British investors, that what about the safety and protection of our investment in your country? You do not have a bilateral investment treaty with us. Dr. Manmohan Singh, being an economist, didn't have much of an idea of what is an investment treaty. And therefore, he came back and instructed his officials in the finance ministry to find out about investment treaties. And this is how India started the process of entering into investment treaties, or sort of seriously contemplating and thinking about investment treaties. So this, yeah, I mean, one can say, looking back, that if this question was not asked to Dr. Singh, then it is possible that India might not have started entering into investment treaties. But yeah, this is how it all started in a way. I'm sure India would have entered into investment treaties even otherwise, but this was in a way a trigger that India started taking investment treaties seriously. And then India picked up on the OECD model of investment treaties, and developed its own model in 1993. And then India subsequently signed investment treaties with a large number of developed countries, initially West European countries such as UK, Netherlands, Germany, Denmark, etc. So from 1994 till about till about 2000, India had signed close to 15 or 18 investment treaties, and most of these investment treaties were signed with European countries. From 2000 onwards, India also started entering into investment treaties with a large number of developing countries. So a very important development during this time was India starting its negotiations for an investment treaty with China, which was ultimately entered into in 2005, 2006, and with a large number of other developing countries. So during this phase, the phase of acceptance, where India started to embrace investment treaties, if you look at the average of treaties signed by India during this period, it is almost 4 to 5 treaties every year. So from a time period when India did not sign investment treaties at all, barring the investment guarantee agreements that it signed with US and with West Germany during Nehru's time. So in comparison to this 4 decades when India did not sign investment treaties at all, post 1991 comes the phase of acceptance because of a new economic paradigm, new economic thinking, liberalization of the Indian economy, faster economic growth. India started signing investment treaties. And if you look at the budget, if you read the budget speeches of Dr. Manmohan Singh, as I've argued in my book, the analysis of those budget speeches very clearly shows that the reason why India was signing these investment treaties was because India wanted to encourage and attract foreign investment. So this was the underlying belief, the underlying assumption that investment treaties are necessary because they would translate into greater foreign investment inflows in India. So it was a very smooth sailing for India from 1991 till 2010. And when I started doing my research on this topic in 2006, and in 2009, when I started doing my research, my doctoral research on this topic, by that time, I discovered that while very few cases had been brought against India, barring one case that was brought by Enron against India, or investment treaty arbitration, which also got settled out of court. It did not result into an investment treaty arbitration award. Barring this one case, there were no cases that were brought against India. However, there were cases that foreign investors had brought against other countries, namely and especially Argentina. A large number of foreign investors had brought cases against Argentina. And the question that sort of I wanted to address is that given the investment treaties that India has signed, is India prepared if foreign investors bring claims against India as well? The reason why this question became important is because all the investment treaties that India signed during this period, the phase of acceptance from 1991 till 2010, all these investment treaties were very, very friendly to foreign investors. In other words, they contained extremely broad and substantive protections to be given to foreign investors. So all of them contained a very broad MFN provision. All of them contained a very broad fair and equitable treatment provision. All of them contained a national treatment provision, so on and so forth. All of them contained investor state dispute settlement provision as well, which, as all of you would know, empowered foreign investors to directly bring treaty claims against the host state. Another very important characteristic of these treaties was that none of these treaties, or very few of these treaties, recognized the host state's right to regulate. So very few of these treaties recognize that there may be environmental reasons, there may be health reasons, there may be other non-investment reasons because of which the host country might have to undertake regulatory measures. And these regulatory measures might be challenged by foreign investor as a potential violation of the treaty. In such a situation, how will the investment treaty arbitration tribunal decide the case? Now, these questions were there, but there were no answers to these questions. So during my field work, for example, when I interviewed officials at that point of time, I did not get a very clear answer. They said that, well, if that was the case, then why no investor has sued us in last 19, 20 years? So they said that I was exaggerating the fears. Just because Argentina has been sued does not mean India will be sued. And today I can look back and say that I had the last laugh, because then India entered into the phase of backlash. And this phase of backlash was one where India started being sued by foreign investors, starting with the White Industries case in 2010. And this is the final part of my book, and about a part about which many of you would have read and you would know that from 2010 onwards or 2011 onwards, India has entered into the third phase in its approach towards investment treaties. And I call this as the phase of backlash. And why is that the case? Let me explain this. So the first investment treaty arbitral award that was issued against India, which is publicly available, is the White Industries Award. Now, I presume all of you know what happened in White Industries, so I will not go into that, but very briefly, this was a case which came up against India largely because of inordinate delay in the judiciary in deciding on enforcement of a particular commercial arbitral award. And India lost this particular case. And after losing this case, all hell broke loose, as they say. And then India finally decided that we need to do several other things. And it was not just this case. if you go back in time a little to 2012, there was another important case decided by the Supreme Court at that point of time, which is the 2G case, where the Supreme Court cancelled the allocation of second generation telecom licenses, saying that these licenses were granted in a manner which is against the law. And many of these licenses were actually owned by foreign corporations or foreign telecom companies. And when these licenses were taken away by the Supreme Court, many of these foreign telecom companies brought ISDS claims against India, alleging that this decision of the Supreme Court violates India's BIT obligations. At that point of time, some people said that the judiciary cannot be an author of an internationally wrongful act, which obviously is completely wrong, because under international law, executive, legislature, judiciary, all the three organs are part of the state, and any of these organs can be an author of an internationally wrongful act. So the cancellation of second generation telecom licenses by the Supreme Court also triggered several ISDS claims against India. The third set of claims that came against India was because of the famous or the infamous amendment in the Income Tax Act retrospectively. Now, again, all of you would know that there was a tax battle involving Vodafone and the union government, where the union government believed that Vodafone owed capital gains tax to India. Vodafone contested this. The matter went to the Supreme Court. The Supreme Court decided in favor of Vodafone. And even before the ink on the judgment could dry, the Parliament decided to amend the Income Tax Act in 2012 and change the income tax law, saying that all such offshore transactions of the kind that Vodafone was involved in are taxable and have been taxable since 1961. So what the Supreme Court had declared as illegal or as a tax which Vodafone did not owe now became a legal demand by the government. And then Vodafone was left with no option but to bring a ISDS claim against India, initially under the India-Netherlands BIT, followed up by another claim under the India-UK BIT. Likewise, in 2016, Kane Energy, another foreign corporation, was sued, armed with this amendment of the Income Tax Act retrospectively for an internal restructuring that it had undertaken way back in 2006. And the Indian government asked Kane Energy to pay a huge amount of capital gains tax, which Kane Energy contested by bringing an ISDS claim against India. Another set of cases that came against India was because of the cancellation of spectrum licenses. This is not the telecom spectrum, but this was there was a case involving the Indian Space Research Organization's commercial arm deal called Antariksh, and for an Indian company in which for Mauritius foreign investors had certain stake. This Indian company was known as Devas. Because of certain reasons, the Indian government decided to annul the contract and take the spectrum back, or not to allocate the spectrum to Devas, which also had an adverse impact on these Mauritius investors and on a German investor who had invested into Devas, the Deutsche Telekom. Because of the decision of the Indian government to cancel these or to take back the spectrum licenses, both the Mauritius investors in Devas and Deutsche Telekom brought cases against India. So because of these slew of ISDS cases being brought against India, India's approach to investment treaties changed completely. So in the phase of acceptance, when India was happily embracing investment treaties without critically thinking about these investment treaties, post 2010, that is from 2011 onwards, India became deeply suspicious of investment treaties. And India decided that we will review these investment treaties. This review of investment treaties led to three important decisions. The first important decision was that India came up with a new model bilateral investment treaty in late 2015, early 2016. The second major development was that India decided to terminate and to unilaterally terminate all its investment treaties. As you know, I hope as students of investment law, you would know that if these treaties are unilaterally terminated, these treaties would nonetheless continue to exist for the next 10 or 15 years because of the sunset clause. And any foreign investment that has come in before the termination will continue to enjoy treaty protection for the next 10 to 15 years. So this was the second major development, that India decided to unilaterally terminate its investment treaties with about 60 odd countries. And the third major development was that India took a decision that with those countries with which it is not terminating its investment treaties, it will try to issue a joint interpretative note. And the purpose of this joint interpretative note will be to make or to clarify the meaning of some of the vague and broad provisions contained in these investment treaties. So India decided that this interpretative note will be issued along with another 13 to 14 or 15 countries. But as you would appreciate, that these interpretative notes, for them to be legally binding, they have to be jointly issued by both the countries. In other words, they have to be jointly issued by all the signatories to the treaty. Which has, in India's case, this has happened only with one country, and that is Bangladesh. Bangladesh has accepted India's joint interpretative note. Other countries have not accepted India's joint interpretative note. So now we have the 2016 model investment treaty. India is using this model to negotiate its future investment treaties. On the basis of this model, India has been able to sign investment treaties with very few countries, about 4 to 5 countries: Belarus, Kyrgyzstan, and a couple of other countries. Those countries which are capital exporters to India, such as US, such as European Union, etc., have not shown much interest in the Indian model BIT. And the reason for this is because they believe that the Indian model BIT has tilted towards protecting the interest of the state and not providing much protection for foreign investment. So the Indian model BIT, as I have argued in my book, contains very limited rights for the foreign investor and provides a lot of regulatory space to the state, which makes it a very unattractive proposition for a large number of countries who export capital to India and who have an offensive interest in terms of investment protection. So I know I'm coming to the end of my time. So I'll conclude by saying that I call this as the phase of backlash, because India is now contesting the investment law regime, or India is now contesting these investment treaties. India believes that these investment treaties do not serve the interests of developing countries such as India. These investment treaties serve the interests of capital exporting countries or of foreign investors. And therefore, India should sign new investment treaties which are more balanced, which is a fine approach, but this balance has not been struck in the Indian model investment treaty. It tilts in the favor of protecting the host state. Finally, I want to end with this thought. When you look at the critiques of the investment treaty arbitration regime in India, they would always point to all these cases that have come up against India, and they will say that it is because of these cases that India has done the right thing by adopting this model investment treaty and terminating its other investment treaties. But my argument is different from this, as I've argued in my book. My argument is that all these, or almost all these claims that have come up against India, are a result of bad regulation or a result of bad governance. Let us briefly look from White Industries to all these cases. White Industries, if the judiciary had not delayed or had taken a decision on the enforcement of the commercial award, the White Industries case would not have happened. Vodafone and Kane Energy cases. If India had not amended its laws retrospectively, Vodafone and Kane Energy claims would not have been brought against India. The Spectrum cases, that is the Devas Multimedia and the Deutsche Telekom cases, both these cases came up because India cancelled the Spectrum licenses without following due process. The Nissan case that has come up against India, again, this case would not have come up if the relevant or the concerned state government was little more diligent in carrying out its regulatory, in adopting its regulatory measure. So if you carefully look at all these cases, none of these cases are of the kind that you will find in, say, Philip Morris cases, where the tobacco company is challenging a health regulation that Australia or Uruguay have adopted. Therefore, in my book, I argue that India is still to experience the Philip Morris movement. There has not been any Philip Morris movement as regards India's experience with investment treaties is concerned. Most of these cases that have come up against India have arisen because of bad governance, because of bad regulation, not because India was adopting a genuine regulatory measure for the protection of public interest, which the foreign investor wanted to challenge. And therefore, the lessons that Indian policymakers have learned, very respectfully, is perhaps not the right lessons to learn. The right lessons to learn should be that you need to internalize the investment treaties. All organs of the government need to be conscious of India's obligations under the investment treaties, and therefore enact and adopt its regulatory measures in a manner that would be compatible and consistent with India's investment treaties. But instead of learning this lesson, India has gone to the other end of starting to terminate investment treaties and adopting a very defensive model of investment treaties. This defensive model of investment treaties is fine if objective is to ensure that no future claims are brought against India. But this defensive approach towards investment treaties will not help India in attracting investment. And secondly, it will also not help Indian investors who are now investing abroad, because the same, because investment treaties are reciprocal in nature. So if there is a defensive investment treaty that India has signed with any country, the Indian investors will also be subjected to the same defensive investment treaty, and therefore they will not be able to protect their foreign investment. So I was given 45 minutes. I think I've taken 46 minutes. I'll end my speech here. What I've tried to do is to give you an overview of all the three phases as I have discussed in my book. If you want to read more about it, please go ahead, buy the book and read it. And of course, I'll be happy to answer questions that you have in the remaining time that we have. Thank you so much. Thank you.
Thank you so much, sir, for sharing your valuable insights on such a contemporary topic. Before students start posing their questions, I have one very simple question, that whether it is the right time now for India to be a part of the exit uh, treaty or the international Center for Settlement of Disputes in terms of bilateral investment treaties, and how should the current debate that is going on at international and domestic level regarding the state investor dispute arbitration model that needs to be adopted at international level should be looked forward to? So what are your insights on this?
Yeah, that's a good question, Taruna. In my view, India should join the exit convention. The reasons for India not joining the exit convention that were valid in 1965 no longer stand. India, because India, I mean, the policymakers want us to believe that India is keen to attract foreign investment. Now, if you're keen to attract foreign investment, then you should also not shy away from giving them protection under international law. And if you're giving them protection under international law, and if you're indeed confident of your liberal democratic credentials, then if you do anything wrong, you should be prepared to be held accountable under the international legal system. So therefore, in my view, India should join exit convention, but I know that this is not a popular view. The popular view is that we need to safeguard our sovereignty and therefore we should not join exit convention. But I have never understood this argument of safeguarding our sovereignty beyond a point. This is like patriotism is the refuge of the scoundrel. Therefore, sovereignty in international law becomes the refuge of every scoundrel who, whenever accused of anything, just shows the placard of national sovereignty, national honor, national prestige, etc., which beyond a point, in my view, does not work.
Thank you, sir. And now the floor is open to all the students. You all can unmute yourselves one by one and address your questions to sir. Rakshit, you have a question?
Good morning, sir. It's Naman. Am
Yes,
I audible?
yes, Naman, you're audible. You can address your question.
Yeah. Thank you, sir, for such an enriching lecture. Sir, my question is relating to the white industries case. Sir, as was happened in white industries case, that there was an undue delay on the part of Indian judiciary, and like that led to judgment against the against our country. So, sir, like, don't you think that it's India who should develop first according to the international norms and international accepted norms, and it is only after that that we'll be able to opt for whether we are whether we are competent enough to join the exit or not join the exit, because currently we are not even in the position to decide as to whether we should join exit or not, because the position as per the international norms has not been reached by India currently, and a development in this regard is required. And so, what are the perspectives on which the line of development shall fall? Like, what are the development criteria that India should look into before, touching that international norm?
Yeah, Naman, see, the way I look at it is if you're waiting for the ideal moment, that ideal moment will never come. It's like saying that a student saying that give me 10 years time, once I'm fully prepared for every single exam, I will write the exam. That full preparation will never happen. So yeah, I agree with you that India needs to develop its capacity, and therefore, and that's a very valid point that you make. And therefore, as I argue in my book and I argued in my lecture also, that India needs to properly internalize its investment treaties. And when I say internalize, it means that all the three organs of the state, the executive, the judiciary, and the legislature, not just at the central level, but also at the state level, should be conscious of India's investment treaties, and they should know that if this is the regulatory measure that we are going to adopt, what will be its impact vis-a-vis India's international law obligations when it comes to foreign investment. Unfortunately, this level of internalization has not happened, as you're rightly pointing out, even within the judiciary, which is surprising. You would expect the judiciary to have internalized, especially the Supreme Court or the higher courts, to have internalized these norms well, but it has not happened. So, while yes, it can be argued that let us develop and build their capacity first, and only then think of joining exit. But I think it's a dynamic process. At times, you join, and then it will force you to learn certain things. So it's like your professor saying that you submit your assignment in 5 days, and then you are compelled to work on the assignment. If the professor says you give the assignment whenever you are free, it is possible that many students might just not turn up and submit the assignment, right? So it's a dynamic process in that sense. And therefore, by joining ICSID, India will be forced to develop its capacity. But yeah, I agree with you that simultaneously, India needs to invest and develop its capacity in understanding ICSID, BITs, ISDS mechanism, etc.
Sure, sir. Thank you so much.
Mitali, you had raised your hand. If you have a question, you can unmute yourself and address it.
I have a question. May I go first?
Yeah, sure.
Good morning, sir, and thank you for such an enriching experience. Sir, my question pertains to the fact that the question that number and the fact that you stated that the sovereignty is not what India should go for. Sir, I mean the question. So, sir, my question is for developing countries, whether it would be fine for the developing countries to be okay with the fact that for these bilateral investment treaties, their sovereignty has been sovereignty of them as a state is being undermined, or whether it would be fine for developing nations to actually go for bilateral investment treaties, because standing on an international realm, these states would start understanding what structural flaws they have, and they can actually try to develop in those aspects and stand in the international realm.
No, so I mean, let me paraphrase myself. I'm not saying that sovereignty is not an important issue. Of course, sovereignty is an important issue, and the very bedrock of international law is sovereignty of nations. So sovereignty is obviously a very, very important issue. All that I'm saying is that if you overplay the sovereignty argument in every single thing, then it might become problematic. Because it's important to understand that the very act of entering into a international treaty, be it BIT or any other treaty, is also an act of your sovereignty, right? Now, to the second question, an important question that you raise about whether developing countries should sign bilateral investment treaties, I think it's important to answer this question. Important to keep two things in mind. First is, what do the developing countries expect to gain from these investment treaties? And secondly, what should be the structure of these investment treaties? Now, if developing countries want to attract foreign investment, many people argue that foreign investment is not dependent on investment treaties. Well, I agree that to a certain point that's a valid argument. Foreign investment is not solely or entirely dependent on investment treaties. But investment treaties do play an important role in attracting foreign investment. That's the first part. The second part is that if a developing country like India wants to sign investment treaties, as I have argued in my book and in my writings, India has to try to develop a balanced investment treaty structure. When I say a balanced investment treaty structure, it means a treaty structure which provides protection to investment without compromising on the state's sovereign right to regulate. Now, this balance is doable. This balance is achievable. What has happened in the Indian model BIT is that this, the pendulum, if in the initial BITs that India signed was towards the end of investment protection, now this pendulum has swung to the other extreme of state protection or state sovereignty. What is important is to bring the pendulum in the middle so that there is a proper balance which is struck between investment protection and the state sovereign right to regulate. If countries adopt this balanced structure, then I think signing investment treaties should not be a problem. And lastly, developing countries often make a lot of hue and cry about ISDS claims. I do not think that while I concede that there are problems in the ISDS system and these problems need to be fixed, if a country is sure about its regulatory measures, if a country is sure that it is not acting arbitrarily, it is not abusing its right to regulate, then it should not be scared or afraid of being held accountable under international law. I mean, there is something. If we have the commitment to liberal democracy, then that commitment has to be shown not just at the domestic level but also at the international level. And if I'm not acting arbitrarily, then the investor, even if the investor brings a claim against me, the tribunal will not decide against me because I have not violated any treaty provision. But if I want to retain the power to act arbitrarily, if I want to retain the power, when I say I means the state, if the state wants to retain the power of abusing its right to regulate and not to be held accountable, then of course there is every reason that the state will run away from the ISDS system. So therefore, the need, in my view, is to have a balanced system, and it is possible, it is achievable.
Thank you so much, sir.
So we have a question in the chat box from one of our students, Yash Shukla. He says that if you could please elaborate on the jurisprudence related to the phrase element of risk from Salini test.
Yeah, so this is a technical question. I mean, when we talk about the Salini test, there are basically 4 requirements which are part of the Salini test. Now, one of the important elements, as Yash has pointed out, is the element of risk, that there should be an element of risk before one classifies something as foreign investment. Now, generally speaking, the jurisprudence on this question is that whenever an investment is made, unless or until the investment is of a very minuscule value, or if the investment has been made just for a few months, etc. Generally speaking, the ISDS tribunals would presume that there is an element of risk in every other investment which is made. So it is not the element of risk which is that much contentious when it comes to Salini test. The far more contentious thing is about the contribution to the development of the host state. And that is where the problem arises, that how do you prove that this investment has contributed to the development of the host state? And that is where even the Indian model BIT, in my view, goes wrong, because it says that one of the important elements of investment is to ensure that that investment contributes to the development of the state. Now, it's a very difficult thing to measure that how and which investment has contributed to the development of the host state. Will an investment which brings in a lot of capital contribute to the development, or will an investment which brings in very little capital but generates a lot of jobs contribute to the development, so on and so forth? So this is a very difficult question, and therefore it is advisable that the characteristics to investment be only linked to the three elements in the Salini test and not include the contribution to the development of the host state.
So because of paucity of time, we'll just take one last question. It's there in the chat box itself, directed by an able student of ours, Shalini Mishra. She is asking that, sir, is the Indian domestic law convenient and compatible with international standards to stimulate foreign investment?
Shalini, to answer this question, you will have to first decide what are the international standards that you're talking about. If the international standards are those that are given in investment treaties, well, then one will have to carefully look at which domestic law, because it will, it would be too sweeping to say that all domestic laws are compatible. One will have to carefully look at the domestic law and then carefully look at the investment standard given in the BIT to decide whether it is compatible or not.
Now I take this opportunity to explain. Yes.
Ma'am,
Ma'am, I have just
ma'am, I
one
have
last
one.
question.
All right. Samek, you can go ahead.
Okay. So, good afternoon, sir. Sir, I have one question, that in many cases we see that the tribunal rule in favor of investors because the broadness of Shalini test led to covering of almost everything in the definition of the investment. So, sir, is there a requirement of a more comprehensive approach towards defining what is investment? Because in your book also you read that almost 60% or more cases are ruled in favor of the investors because the tribunal take each and everything into the definition of the investors.
Samyak, in my book, I have not argued what you are saying. I don't argue that these cases are won by the investor. In fact, I argue the contrary. And the statistics actually prove that. If you look at the untouched statistics, states have won more cases than foreign investors. So the tribunals have ruled more in favor of states than in favor of foreign investors. It is this is just an advice to all of you, all the law students. We lawyers are so consumed and focused on these technicalities, doctrinal technicalities. We often don't look at the empirical data and the evidence. And it's very, very important also for us to look at the empirical data and the evidence. So UNCTAD produces some fantastic statistics on investment treaty arbitration, ISDS, BITs, etc. And if you look at the UNCTAD statistic, then it very clearly shows that the states have won more than foreign investors overall. Now, coming to your specific point, Samyak, yes, you are right that if you have a foreign investment definition which is very broad, then obviously it would give the ISDS tribunal jurisdiction over a large number of claims. And therefore, I agree with you that foreign investment needs to be defined carefully within an investment treaty. Now, my suggestion to treaty drafters would be that you define foreign investment incorporating the 3 out of 4 of the Salini tests. And if you keep these 3 elements out of 4 from the Salini test, then you would be able to draft a decent definition of investment, which would ensure that portfolio investment or speculative investment, investment which comes in and goes out, that kind of investment is excluded from the treaty protection. But at the same time, other important elements, other important investment which have element of risk, which have a duration element, etc., those investment would still continue to enjoy protection under the investment treaty.
Thank you, sir. Now I take this opportunity to express my gratitude as well as I would now ask our student Shalini to propose the vote of thanks on behalf of the institute, on my personal behalf, as well as all the students. And thank you so much, sir, for sparing your valuable time and sharing your insights on such a contemporary and important topic. Thank you. Shalini, over to you.
Before Shalini comes in, can I just say that I would also like to thank Nikita for her invitation. I think she was the one who contacted me initially, and also to you, Taruna, for moderating this, and to all the students. Thank you very much, and I wish you all the very best. My only advice to you is that please focus on the doctrine, but also be critical in looking at everything that you see, and also sort of spend your time and energy looking at empirical data and statistics. Thank you.
Thank you so much, Dr. Prabhat. It was lovely hearing you. I think it was one of the most interesting lectures that I've also heard in the field of ADRs. Thank you so much for taking out time on a Monday morning. Thank you.
Hello, am I audible?
Yes, Shalini, you're audible.
A very good afternoon to one and all. At the outset, I would like to extend my heartfelt gratitude to Professor Prabhat Ranjan for taking out time to provide us with insights into the crucial aspects of India and bilateral investment treaty. We refer your book in our investment law course, and to get an opportunity to hear from you is indeed an honor and privilege for all of us. Thank you, sir, for providing us with an enriching and valuable insight into the niche area of investment law, and it has helped us to learn more about this up and coming field. I would also like to thank our Dean and Director, Professor Dr. Purvi Pokharial, for giving us all the opportunity to be a part of such an enlightening session. I would also like to extend my gratitude to the faculty coordinator of this event, Professor Taruna Jhakar and Nikita ma'am, for ensuring all the modalities for this event. At last, I would like to thank all the participants for being an active and patient audience. Thank you, everyone. Have a great day.